It's like we're good now.
Let's see. All right, so it's setting it up. So I'm on the YouTube side now, just letting it go through. Okay.
Okay, I see it. I see live on YouTube.
Okay, perfect. Okay,
Thanks, Josh.
you're welcome. I'm going to transfer it back over to you. Hopefully if I can back out without it. I wonder if I need to actually stay in order for it, the YouTube to not disconnect. Hold on. Let me try this. Okay.
Still live, and I'm the host, so I think we're okay.
Okay. All right. I'll back out. Text me if this crashes and burns while I'm gone.
Thanks, Josh.
Thank you very much.
Thank you,
Bye.
Josh.
What a hero.
Still says we're live.
Yeah, it looks like we're still live on YouTube right now, so we should be good.
Okay, terrific. Thank you, Jenny and Margaret and Josh. And we apologize to the folks that are watching and expected us to start at 1. We had some technical difficulties, which we've now resolved. So I'll begin by welcoming everyone. I am Senator Sharon Carson from District 14. Today, we will be holding a meeting of the Senate Judiciary Committee. Before we get started, I'll read through a checklist to ensure that the meeting we are holding is in compliance with the right to know law. As the chair of the Judiciary Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic and in accordance with the governor's emergency order number 12, pursuant to Executive Order 2020-04 and its extensions, this public body is authorized to meet electronically. Please note that there is no physical location to observe and to listen contemporaneously to this meeting, which was authorized pursuant to the governor's emergency order. In according with the emergency order, I am confirming that 1, we are providing public access to the meeting by telephone with additional access possible by video and other electronic means. We are utilizing Zoom for this electronic meeting. All members of the committee and selected legislative staff have the ability to communicate contemporaneously in this meeting through this platform. And the public has access to contemporaneously watch and/or listen to the meeting on Zoom or YouTube and via phone by following the directions and links provided on the General Court website. 2, we have provided public notice of the necessary information for accessing the meeting in the Senate calendar. 3, we are providing a mechanism for the public to alert the public body during the meeting if there are problems with access. If anyone has a problem, please email remotesenate@leg.state.nh.us or call area code 603-271-6931. 4, in the event the public is unable to access the meeting will be adjourned and rescheduled. 5, please note that all votes taken during this meeting shall be done by roll call vote. 6, finally, let's start the meeting by taking a roll call attendance. When each member states their presence, please also state where they are and if anyone else in the room with you if anyone else is in the room with you during this meeting, which is required under the right to know law. I will call the roll. Senator Gannon?
Yes, this is Senator Gannon at Phillips Pond in my home office. I'm alone and plan to stay that way during the meeting.
Thank you. Senator French?
Harold French, Senator, District 7, broadcasting live from an undisclosed location in Canterbury, New Hampshire. I am secure, as I hope you all are. No one is in the home.
Thank you. Senator Khan?
Present in Keene in my home. My wife is elsewhere in the house.
Thank you. Senator Whitley?
Senator Whitley here in my home in Hopkinton. I'm alone in the room, but my family's in the house.
Thank you. And Senator Carson, I am at my home in Londonderry. My daughter is in an adjacent room. And I must warn you, my cat Ralph might decide he wants to make another appearance. So if you see a cat, you know it's Ralph. So thank you all very much. We're going to get started by opening the public hearing on Senate Bill 94. And I'm going to turn the gavel over to Senator Gannon because this is my bill and I will introduce it.
Thank you. Thank you, Senator Carson. Go ahead with Bill 94.
Thank you very much, Mr. Chairman. For the record, my name is Sharon Carson, and I have the pleasure of representing Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And I have for your consideration this afternoon is Senate Bill 94, relative to juvenile diversion programs. This bill clarifies the procedure for obtaining a needs assessment through juvenile diversion prior to proceeding with a delinquency petition under RSA 169B. Mr. Chairman, this bill was brought at the request of the Juvenile Justice Transformation Group. This bill amends 169B:10, the diversion section of the Juvenile Delinquency Chapter, to expand the ability to provide youth with assessments and services prior to court involvement. This bill requires law enforcement and prosecutors to refer youth for a needs assessment prior to filing a delinquency petition, except in limited cases involving the most serious offenses. The proposed assessment is voluntary and is intended to allow the department to identify and address the needs of youth prior to court involvement, with the goal of decreasing the overall need for court involvement with the provision of the appropriate community services. There are a number of people from the Transformation Work Group, including individuals from DCYF, the courts, and the Office of the Child Advocate, who are here to provide further explanation and may answer any questions that you have. Thank you very much, Mr. Chairman.
Thank you very much, Senator Carson. And yes, Senator Whitley, go ahead.
Thank you, Mr. Chair, and thank you, Senator Carson, for bringing this work forward. I see that this could be an extension of all the important work that's been done to build the system of care. Would you agree with that?
Yes.
Thank you.
Okay.
Any other questions? Committee? No. Thank you, Senator Carson.
Okay, so I will go ahead and take over. Thank you very much, Senator Gannon. Next, we're going to call Joseph Ribson.
Good afternoon, committee. Joe Ripsum, Director, DCYF. Rebecca Ross, who's our General Counsel, is also in with me today, and if I'd appreciate if she could be brought over as well in case there's any questions that would require her assistance as well.
That would be fine, Mr. Ribson. Just make sure that if Ms. Ross is going to speak, that she identifies herself for the record.
Excellent. Great. So while she's being brought over, I will begin. Again, my name is Joseph Ripsum, the Director of DCYF. I am in my office in Concord alone. Thank you, Senator Carson, for bringing this bill forward, and thank you, committee, for hearing this. This is a really important piece of legislation to help in our juvenile justice transformation project. As Senator Carson alluded to, this initiated with work that's being done with what we call our juvenile justice transformation team. That's a group of us who in November 2019 had the opportunity, received an opportunity and a grant to go down to Georgetown University, work with national experts and the Annie Casey Foundation on learning a bit about the latest of what's happening within juvenile justice, and to come up with a plan for things that we could do in New Hampshire to help improve the experience of young people who, find themselves getting into trouble. That team included myself, two other members of the juvenile justice staff here at DCYF. That's Amy McCormick and Rich Surrett. Also included our child advocate, Moira O'Neill, Judge Ashley from the courts, Nicole Rodler, who's the chair of the Juvenile Diversion Commission or Committee. I might have that wrong. Network. Nicole Rodler. I'm sorry, I got her already. A couple other people here. Pamela Jones, who is from the Public Defender's Office, and Steve Ranfos, who is a prosecutor out of Manchester. So the idea was to try to get folks from different aspects of the system together to think about how these things could work better for the benefit of youth across our state. This legislation represents an important part, but not the entirety of that transformation project. Other aspects of it are going to be forthcoming in the months, years to come. What this piece of legislation primarily does, as Senator Carson spoke to, is it creates a process by which we can identify the needs that youth have sooner than we currently do, and we can connect youth with the services that they need in order to prevent them from getting into the deeper end juvenile justice system. Oftentimes we find that youth need a behavioral health intervention like our Fast Forward program, or a diversion program like our local diversion programs, or maybe they just need to be connected to some recreational activities to keep themselves occupied in, pro-social positive developments, or local YMCAs or Boys and Girls Clubs, or any number of other activities that we can be helpful in connecting youth with those things in a way that will help stabilize them and their families and prevent them from getting deeper into the system. The way that this bill proposed to do that is that when children come into contact with law enforcement may make a referral to us even without arresting a youth. If they do arrest a youth, they must make a referral to us before they file a petition, unless there's an immediate issue requiring, say, detention or removal from the home into a shelter space or something like that. Of all the youth who are arrested and petitioned, that is a very, very small minority of the total. But in those instances, we didn't want to make the completion of the assessment a barrier where there was an immediate safety concern. From there, DCYF staff, juvenile justice staff who would be specialized in this work will conduct this needs assessment, make referrals to services as appropriate, and provide information to the referring entity, the referring law enforcement entity, as to whether we think it's necessary to move forward with the petition or not. That is not, it doesn't direct law enforcement what to do. They can choose to move forward with the petition in any instance, but what we expect to happen is that if they see that youth are being served in the community, that they will not move forward with unnecessary petitions. It just doesn't serve anybody's time or effort to do that. Couple other key things. It's important to note this assessment we're talking about is voluntary. We're not compelling any youth or families to participate in it. Of course, if they don't participate, law enforcement will proceed, the way that they would otherwise. That may be to petition or not petition, but youth and families are able to avail themselves of this, but they're not required to. And the information from this assessment is not allowed to be used against the youth in the adjudicatory process. So if the youth comes in for an assessment and we identify certain needs, and in that process, information is revealed that would be potentially be able to be used against them in their adjudicatory process, that information is not allowed to be used in that way or shared in that way. This is really about trying to get kids the things they need. The last piece is that it would allow information if a youth is ultimately petitioned and ultimately does go through the court process. It will, with the consent of the youth and their counsel, allow this assessment to be used by the courts and by the attorneys, by the juvenile justice staff to help inform the development of a treatment plan for youth who do go through the full process. One of the things that we see today, unfortunately, is that a lot of times dispositions following the court cases are made without the availability of really good information about what the youth actually needs. So people start creating plans without ever doing the assessment to understand what needs to be done with them. What this would do is allow that assessment that was previously conducted to then be used towards the end of the case to make sure that we're actually meeting youth's needs and being more effective with what we provide youth, instead of just assigning them to services that may or may not be appropriate for their needs. There is an amendment to the bill, I think, that is being shared. That was language that we worked on with a host of stakeholders who had some good ideas about things that we might have overlooked or could have clarified in the original version. I don't think it substantively changes the intent of the original bill, but it does clarify some of the processes, and I think makes it a stronger piece of legislation in the end. So with that, I'm happy to take questions from anybody.
Thank you very much for your testimony this afternoon, Director Ribson. Senator Whitley has a question.
Thank you, Madam Chair, and thank you, Director Ribson, for what sounds like is a really collaborative process in bringing this bill forward. So thank you for that. My first question is if you could share with the committee how this bill connects to the work to build the system of care in New Hampshire for children with complex behavioral health needs, and in particular the connection to SB 14.
Yep, thank you for that. And yes, I think it integrates really well with that. In fact, I think a lot of the work we're doing in DCYF in child protection, juvenile justice, and children's behavioral health, which sits outside of DCYF, is all interconnected in these ways. And in the most simple way to think about it, it's just about being able to quickly identify needs and connect youth and families with the services to meet their needs. Within children's behavioral health, there is a high fidelity wraparound model that's been around for a couple of years called Fast Forward, which connects youth and families with the behavioral health services that young person would need, support for the families to ensure that the families are able to keep that young person in the home. It's been very successful. It's actually being built out to support additional youth who get involved in our residential programs. pursuant to work that we've been doing over the past couple of years. What this one thing that this will do, and you do see it referenced within the amendment, is that if a youth presents during one of these assessments of having complex behavioral health care needs, that the department will be referring that youth to that Fast Forward program to have those needs met. And what I anticipate we'll see is that some of the young folks who would otherwise come deep into the juvenile justice system will end up in that program voluntarily and have their needs met there.
Thank you. Follow up, if I may?
Sorry,
So
my
could you-
doggies are barking. Yes.
No problem. Thanks for that, Director Ripsum. So I'm curious if you could share what the needs assessment entails. Is it like is it the CANS assessment, or is it something different?
Yeah, the plan is to use the Child Adolescent Needs and Strengths tool, the CANS tool that you referred to. What that does is it goes through a host of domains around things that kids might need, but also goes through a host of domains focusing on what their individual and their family strengths are. With the idea being that with all of that information gathered, you can create treatment plans that build upon the strengths to address the needs, and ultimately allows you to support that youth within their own family and with their own natural resources. Part of the whole idea of using a tool like this and then using this high fidelity wraparound model like Fast Forward is that it moves over time so that families can meet their needs with their youth and their own natural resources where appropriate. The idea with the CANS, using it in this venue, as well as it's currently used in our behavioral health system, and ultimately we intend to use it within our child protection system as well, is so that you have a common language and understanding of needs and interventions across these different systems that kids pop up in. Kids can appear in any one of these systems at any time, and one of the big challenges we have today is our systems don't really know how to talk to each other about needs because we all use different language. So if we're all using a common assessment tool, the hope is that that's going to allow us to better plan collaboratively, and an additional benefit, allow kids to move through these different systems at different times based on what their needs are. An example of that would be, we'll often have a child who's involved with juvenile justice, and it turns out they have a behavioral health care need. So then they also get involved with behavioral health care system. We currently end up having kids stay in the juvenile justice system to get those behavioral health care needs met, which doesn't make a lot of sense, right? If their delinquency issues are resolved, juvenile justice should close out their case, and that kid who still needs help can get help through the behavioral health care system without having to have juvenile justice and court and everything else in their lives. And by having the common tool and having the common system, this common use of Fast Forward across these systems, you end up with a situation where youth can be where they need to be to have their needs met without artificially keeping coercive services like court involvement services in place where it's unnecessary.
Thank you. Another follow-up, if I may?
Follow up?
So, I see the importance of doing a standardized assessment, and I'm happy to hear that. And I'm interested in how you'll be tracking those needs assessments and those referrals that result from the needs assessment.
Yeah, so some of the details aren't totally worked out yet, but the idea behind using the CANS is that there's already a web-based version that's used within children's behavioral health, and expanding out that access across so we can use that to track what type of services are needed for kids, what types of needs are being addressed or need to be expanded, but also so that we can track progress over time. The use of the CANS is not intended to be a one-time first day assessment. It's intended to be done, pretty much quarterly. And it's a way that you can see that progress is actually being made through a treatment episode, which is something that really lacks in our system today. We trust that kids are getting better, but we don't actually have a tool to measure that kids are getting better. So the use of the CANS helps with that. It then also helps years later, and I speak from experience because we used the same tool in New Jersey for the same purpose. Once you gather enough data over years, you can actually use it to see how successful providers are. You can see who are your providers who typically let kids get better and who actually does a good job of getting kids better and who doesn't. And that information can then be used for making decisions about, who you're going to contract with in the future and what services you want to keep and what services you'd let go.
And thank you, Director Rosen. One final question, if I may?
Yes.
So the last thing I was interested in is has the transformation team contemplated about what training will look like with law enforcement if this bill is to pass?
Those are all part of the ongoing implementation kind of conversations. The plan for this bill would be that it would be initiated. If you look at the very end, there's kind of a rolling implementation. It'll be initiated starting in January of 22 in about 1/3 of the state, and then rolling throughout the rest of the state over the rest of that next year. So yes, we're still working on exactly what training will look like for that, but I think we'll be able to figure that out. We have really good partners with Annie Casey Foundation and others who are working with us on this effort, and I'm sure will help us create a strong training module for folks.
And it might benefit to work with Chief Skippa at the Police Training Standards and Council also.
Absolutely.
Thank you.
Okay, are there any further questions for Director Ribson? Senator Khan?
Thank you, Madam Chair. And greetings, Director Ribson. So it sounds that you've really integrated this well with your other system of care ideas. I'm impressed. The initiatives of the department. Have you worked with the county attorneys on this?
So at this point, they've been engaged somewhat throughout this process. So we do have a prosecutor who's not with the county attorney office who was part of the initial team. What we've been doing through the transformation process to this point was we've had what's called a kind of like a 101 session where about 500 people, including some folks from the county's attorney's office, participated. And then we had what we're calling affinity groups, where every week we get another group of folks together. One of those affinity groups was for law enforcement and prosecutors. We had a number of folks at that meeting. So through those venues, those folks have had the opportunity, and some have engaged with us. But certainly if there's other folks that should be at the table, we're happy to have other folks at the table too. If there's anyone you're thinking of.
The follow-up? Yeah, thank you. Have in those conversations, have there been instances where there's been a request or a suggestion that there ought to be petitions possible without a prior assessment?
That issue hasn't been raised, and the way that the bill is currently written, though, there is the ability to file a petition prior to an assessment if you need to make an emergency placement. So if you have a child who's committed an act that would qualify them for detention at SYSC, or through otherwise poses a risk to their family and the community, and they wanted to say place them in a shelter, is where typically they would go for a short-term placement pending further assessment. That's allowable already in the statute or in the bill. The other thing is typically, other than those instances, petitions aren't filed for a month or so. They're not typically filed immediately. So part of the design of this was to ensure that we were going to receive the referral quickly and conduct the assessment within 30 days so that we wouldn't interfere with the filing of a petition. And then, of course, if a youth or a family refuses to engage in the assessment, they can file a petition at any time without waiting for the assessment.
Thank you. And
Follow-up?
Could you go over, thank you, Madam Chair. Can you go back over what is the nature of the amendment?
Yeah, the amendment has a couple different pieces in it. It has one section which just kind of further clarifies in the statement of purpose around the use of these assessments later in the process if kids do end up in the court process. There is another change, another amendment in it, which just makes it very clear. I think we tried to capture it in the first version, but wanted to make it very clear that law enforcement can refer for an assessment, even if they don't arrest a young person, right? So if law enforcement goes out and they encounter with a young person, they have a concern, they can make that referral, but they don't have to arrest the child first. There was some concern that people might read the original version as requiring an arrest to get an assessment. We didn't want that to be, a prerequisite to getting kids the help they need. There is another amendment which just specifies that if during the assessment process it appears that a child has a substantial behavioral health need, that they'll be referred to that fast forward program that I spoke about. That was always the intent, but folks wanted that clarified, and we were happy to include that clarification in the language. There was another change that just made clear that the assessment can't be used during a disposition phase without the consent of the youth or the attorney. Part of the reason for that is that young people and families won't typically have attorneys when the assessments are being conducted. and might disclose information that they might not otherwise disclose had they been advised by counsel. So we didn't want to create a disincentive for young people and their families to share with us openly through the assessment process by having a fear that that might be used against them at a later date. Really, this is about giving kids the services and help that they need. And we didn't want people to think that we're trying to, somehow trap them into some kind of legal process when that's not what this is about. And I think that's it. At least those are all the substantive amendments. There might have been a couple non-substantive corrections.
Thank you, Madam Chair, and thank you, Director.
Thank you. Are there any further questions for Mr. Ribson? Senator Whitley?
Thank you, Madam Chair, and thank you, Director, for taking another question. So I'm just looking at on the amendment, page 2, line, what you were just referring to, line 26, that's the referral to fast forward.
Yep.
And just thinking through, I don't know if this is a question for you or for Erica Ungarelli from Children's Behavioral Health, but whether we should just be referencing, referral to a care management entity under the appropriate statutory provision under SB 14. I don't know if the fast forward program doesn't appear in statute. It's just sort of the name of the program. So that's an open question.
Yeah, we struggled with that because it was originally written that way. And the challenge is the way that the system's developed. The SB 14 care management entity is what was designed out of that. It's what's currently being referred to as TREC, which probably doesn't mean anything to most of you, but I think Senator Whitley, you're familiar with that. And it's a different program than what kids would typically get referred to here. That program is for kids who are engaged in the residential system, where this is typically pre-residential system. So that's why we landed on calling out the Fast Forward program. I'm okay with changing it to refer to a care management entity. I'm just conscientious about referring to specifically the SB 14 care management entity because it's somewhat different.
Yeah, and that makes sense to me. Just a question, so currently both care management entities
Do both.
Have a fast forward program, correct?
Correct. Currently they both do, but I don't know that that's a necessary, that might not always be the case, right? The system could change over time. So we didn't want to pin that in.
Thank you.
Okay, are there any further questions for Mr. Ribson? Okay, seeing none. Thank you, Mr. Ribson. Ms. Ross, do you have anything you'd like to add?
No, thank you, Senator.
Okay, thank you both very much for your testimony this afternoon. Next, we have Judge Susan Ashley.
Good afternoon, Senator Carson. Are you able to hear me?
Yes, we are.
All right, wonderful. Thank you. And I appreciate the opportunity to have a chance to speak on behalf of this bill and in support of the bill this afternoon. So thank you for the time of the chair of the committee, Senator Carson, as well as all of the committee members. So as a member of the New Hampshire team that was able to travel to Georgetown and study juvenile transformation there, it's really been my privilege to work with this group who represent the different entities that have very specific interests in juvenile justice in New Hampshire. And we have had some really detailed conversations to get us to this stage and in the development of this legislation before you today. As Director Ribson covered in great detail, the capstone project for New Hampshire has many facets, but it could be directed at sort of a front end of the project as well as a back end, which the back end would be more towards making sure that our dispositional orders for those kids who are on probation are individual, are developmentally appropriate, are equitable in terms of racial and ethnic issues, and they're achievable for the youth involved. And so we will be doing substantial work on the back end, shall we say, but this legislation really covers the front end of really who should be coming into court. And while we have had our diversion statute in place, I think that it is fair to say that we have communities who really embrace assessing kids on the front end and diverting them from court, and other communities who have not been able to accomplish that level of diversion. And so this bill, with the ability to have the assessment for all of the youth who interact with law enforcement, would be addressing that throughout the state of New Hampshire, so that that opportunity would be available for all youth to be assessed. And then hopefully there will be that determination that community-based services may be able to better address their needs rather than needing to file a petition and bringing them into the juvenile justice system. For those who do need to come into the juvenile justice system, we will be ready and available to receive those petitions. A court is a very stressful environment for really anyone who comes in, and certainly for our teenagers who may be petitioned into court. So if there are other services that may be more appropriate for them, we want to have them have that opportunity. So I do speak in support of the bill. I'm happy to answer any questions. I think you've had a great overview from Dr. Ribson, so I will cut my comments short and hopefully answer any questions that you may have.
Okay, thank you very much, Judge. Are there any questions for Judge Ashley? Okay, seeing none. Thank you very much, Judge.
Thank you, ma'am.
Next, we have Michelle Wongarin.
Good afternoon.
Good afternoon.
Thank you, Honorable Chairwoman and members of the committee, and thank you, Chairwoman Carson, for bringing this bill forward. My name is Michelle Wongarin, and I'm the Youth Law Project Director at New Hampshire Legal Assistance. My project provides civil legal services to system-involved youth and youth at risk of system involvement. And I just want to be clear that while I signed in as neutral on this bill, I want to clarify that with the amendment before the committee today, I am in full support of SB 94 with that amendment. And so as you've heard, SB 94 and the accompanying amendment are the product of what I think is a tremendous collaborative effort involving both the Juvenile Probation Transformation Team and a cross-section of community stakeholders. This bill is a necessary first step to ensure that New Hampshire serves youth in a way that both holds youth accountable for their choices and ensures that normal youth mistakes don't control and in fact change the course of their lives in negative ways. As I know this committee has heard before, despite the design of the juvenile justice system as a treatment-oriented system, the reality is that it often has a profoundly negative impact on youth who become entangled within it. Not only does the system often engender a delinquent youth identity in involved children, it's well documented that a single court appearance dramatically increases the likelihood that children will drop out of school and become involved in the criminal justice system later on as adults. It's important to remember that so much of youth growing pains and misbehavior could amount to a crime if committed by an adult. But we also have to remember that kids are not adults, and how we approach their behavior will likely determine whether they learn and grow from their experiences or whether they solidify their identity as delinquents and later as criminals. Not only does this legislation fulfill the original intent of the Probation Transformation Team, but with the amendment, it ensures that the state accomplishes those worthy objectives in a manner that maintains the constitutionality required due process protections to which juveniles are entitled. This bill, as amended, will ensure both maximum flexibility and objectivity within the juvenile justice system. It will hold kids accountable in the most effective and developmentally appropriate ways, and will hopefully prevent the over-pathologization of youth misbehavior when that behavior is part of the normal developmental process. For instance, if kids need a stern warning and talking to by figures of authority, our hope is that they will receive it. If kids need to make amends to a victim, the system will hold them accountable and do that in a way that doesn't necessarily require court involvement. If kids are struggling through problems that are much bigger than themselves or even their families, they can and will have access to services thoughtfully designed to address those problems. And if kids truly do need court involvement, that system will be there as well. While much of this, I think, could be accomplished today in many areas of the state through prosecutorial discretion and the use of diversion programs, quite frankly, it often isn't. I think this bill is an important step towards ensuring children across the state are treated roughly the same, regardless of their race, their geographic region, or their socioeconomic status. What's special about this bill and the amendment is that decisions will be made based on objective needs assessments rather than relying on explicit or implicit biases found within the system to determine the state's approach to youth misbehavior. I think that step is critical to making sure that the system works appropriately and fairly for all youth. SB 94 is an initial step toward what I think is going to be a much better system. I'm incredibly excited about and proud of the initial legwork and subsequent collaboration that's gone into this bill and the accompanying amendment, and I urge the committee to vote ought to pass on both. I'm happy
Thank
to.
Thank you very much for your testimony this afternoon. Are there any questions for the committee? Okay, seeing none, thank you very much. Next, we'll call Peter Lewellen.
Good afternoon. Can you hear me?
Yes, we can.
Senator Carson and honorable members of the committee. My name is Peter Lewellen. I live in Wolfboro, New Hampshire. I am a lifelong resident of the state of New Hampshire and have served as a police officer for over 21 years. During my career, I've worked in various roles to include juvenile prosecutor and school resource officer. As such, I've spent over 10 years working with the juvenile justice system. I've also served on boards involved with today's youth, and I currently coach them as well. Today, I am here representing the Wakefield Police Department, where I am currently employed, as well as the New Hampshire Juvenile Police Officers Association, of whose board of directors I currently serve on. New Hampshire Juvenile Police Officers Association was established in 2019 as a result of the governor's 2018 School Safety Preparedness Task Force report. That recommended an organization to provide guidance and support to SROs, school safety professionals, and educators within New Hampshire. The NHJPOA, as we're known, is affiliated with the National Association of School Resource Officers. Today, I am here to speak in opposition to Senate Bill 94 on behalf of myself, the New Hampshire Juvenile Police Officers Association, and the Wakefield Police Department. We submit that the current RSA 169B10 addresses the needs and services for today's youth. It requires authorized officers to take a minor into custody and allows for them to dispose of the case without court referral. It also requires the arresting agency to screen the case for diversion prior to filing a delinquency petition with the court. If a petition is thought to be the best course of action at that time, it has requirements that need to be met in order for the court to know why the particular case does not meet the standard for diversion. Some people may state that a needs assessment is necessary to provide our youth with what they need. Some may say that they need more that is being provided, and that is why the bill is so important. Having dealt with hundreds of youths during my career, I feel the youth I have dealt with have always had their needs met to the best of the juvenile justice system's abilities. This includes diversion prior to court involvement. We believe that by adding another layer of bureaucracy by getting DHHS involved will not benefit the youth of our state. We believe that this will also further delay the youth receiving the needs and services that they may require. We also believe the bill will further inhibit JPPOs from doing their job and circumvent the court system, which is often the only way we get services to these youth. To summarize, Senate Bill 94 appears to want to limit the ability of the arresting agencies and JPPO's abilities to act in what they deem as the best interest of the youth. The bill's language appears conflicting in nature and appears to have been written to undermine the current system. By adding DHHS to the mix, it is our opinion that it will not help the youth, but in fact be detrimental to what their actual needs are. In closing, I ask that you find this bill inexpedient to legislate. Thank you for your consideration.
Thank you very much for your testimony this afternoon. Are there any questions from the committee? Senator Whitley.
Thank you, Madam Chair. Thank you, Officer Lewellen, for taking my question. I'm wondering if you're aware that the vast majority, 3/5 of the children that enter the juvenile justice system have complex behavioral health needs and disorders.
No, I'm not aware of that.
Thank you.
Thank you. Are there any further questions? Okay, seeing none. Thank you very much for your testimony this afternoon. That is all the folks that we have signed up to speak. Are there any folks in the waiting room, Margaret?
Yes, so far there are 3.
Okay.
First one I see is Michael Gibby. And then
Okay.
we have someone under New Hampshire Child's Advocate. And Cody Belanger.
Okay. Okay, I believe that's Representative Belanger, so why don't we go to him first?
Hello, good afternoon, everybody. Can you hear me okay?
Yes, we sure can, Representative.
Thank you, Madam Chair and members of the Senate Judicial Committee. Thank you, everybody, for hearing my testimony today. For the record, my name is Representative Cody Belanger. I represent the town of Epping, also known as the center of the universe. I am also a co-sponsor on this bill, and I am proud to do so. As we have continued to see changes in our DCYF programs, juvenile diversion, and most recently a bill in the House which reduces the types of crimes that a child may be brought to SYSC. We have heard today the benefits that juvenile diversion programs bring to the youth in our state. I myself am a child of the system. I spent a better part 4 years of my high school years in and out of SYSC, boys group homes, juvenile diversion programs, and today before you, you see an established young man married with one soon-to-be adoptive son and a growing family. We are told that young children who have issues in the home, whether that be in and out in the judicial system or not, need one strong role model who cares about them. Oftentimes, the person that they see in a diversion program could be that person. We also hear other things, but each individual youth, shares a different story. No individual youth has the same story as the next. As I believe 2 previous speakers before me in her testimony, she alluded to that kids aren't adults, and she's correct. Their behaviors can change. They can be successful members of society, given the supports that they need. This bill would help address one of the many needs that kids who, like myself, that I used to be, would be used to our benefit. I urge the committee to OTPA. Thank you, Madam Chair and members of the committee.
Thank you very much for your testimony, Representative. Are there any comments? Any questions from the committee? Senator French.
Thank you, Madam Chair. Thank you, Representative. Looking at your photograph, I can see you were probably a problem child. I'm glad you overcame it. So
just ask Senator Gannon, sir.
You experienced the program we have in place now. Why would this one be better?
So as I alluded to in my testimony, each individual's youth is not the same story as the next. So my assessment may not be the same. So my needs, would be met differently than another student, if you will, if that makes sense.
Great, thank you.
Okay, are there any further questions for Representative Belanger? Okay, seeing none, thank you very much, Representative.
Thank you.
Next, we're going to call Mike Skibby.
Good afternoon, Madam Chair and members of the committee. Mike Skibby. I'm Policy Director at the Disability Rights Center of New Hampshire. I'm also part of the Juvenile Reform Project, which is a collaboration of New Hampshire legal assistance, my office, ACLU, Waypoint. I want to thank Senator Carson for your sponsorship of this bill. My office supports the bill, particularly if it is amended according to the amendment that Mr. Ripsum described. I appreciate the outreach from Mr. Ripsum and his staff to the Juvenile Reform Project to discuss this bill and to develop the amendment that is before you. I think that this process really reflects the challenge that we have when we're trying to protect children's constitutional rights at the same time that you're trying to evaluate them and provide services to them. The way that this tends to work is that you're gathering information at the same time that a prosecution is pending. And so that's fraught with danger of violating the right against self-incrimination or the right to counsel, or both. The amendment before you, I think, succeeds in harmonizing those two sometimes competing purposes. I think it does that by making sure that the use of the information that is gained during the evaluation process is limited to what is consented to by the child with the assistance of counsel. I think the use of these evaluations will mean that interventions will be much more likely to be treatment-oriented and intelligently treatment-oriented, and therefore more likely to be successful. I think it'll be good for children, it'll be good for their families, it'll be good for public safety because recidivism will be reduced, and it'll be good for the use of scarce public resources because they'll be much more likely to be effective. To briefly respond to what Officer Lewellen said, I don't think that this bill, either with the amendment or without, limits the options of police or prosecutors. It simply gives them additional information so that their decisions about whether to proceed to court are better informed, and therefore it'll be a good use of their resources as well. I'm happy to answer any questions.
Thank you very much for your testimony, Mr. Skibby. Senator Whitley has a question for you.
Thank you, Madam Chair, and thank you, Attorney Skibby, for taking my question. I'm wondering if you could share with the committee what you know about the nature of New Hampshire children that do end up in the juvenile justice system. My understanding is that nationwide, the vast majority of children that do end up in juvenile justice, and particularly deep end in juvenile justice, have very complex behavioral health needs.
Thank you. Yes, that's true. In New Hampshire, I was involved in a study of the incidence of disability among court-involved and generally system-involved youth in New Hampshire about 15 or 20 years ago, and it confirmed what is generally understood to be true around the country, that there's a very high rate of particularly behavioral health disorders and other disabilities among children who become involved in the court system. And that sort of overrepresentation tends to be higher in more restrictive placements, so that you would find the highest rate of behavioral health disorders at some place like the Synonym Youth Services Center. And representatives of the department testified a couple of years ago before one of the finance divisions that at the time of their testimony, 100% of the children that were held that day at the Synonym Youth Center had a behavioral health disorder. It tends to be lower, sort of earlier in the system, but the more deeply involved a child becomes, the more likely they will have a significant disorder of that nature.
Thank you. Follow up, if I may?
Yes, please.
Thank you, Madam Chair. So sort of building on that, is it your understanding that children show up in the juvenile justice system? They might have an encounter with police because of an unmet treatment need or behavioral health need in their past or in their present?
Yes, it's very common that what you find upstream of court involvement is an unrecognized and unaddressed behavioral health disorder. And oftentimes you will see this in the school system, for example, where a behavioral health disorder was not recognized and therefore it wasn't addressed, and therefore, behaviors began to develop and they were dealt with as a disciplinary matter rather than being addressed with appropriate treatment. You'll see that in the school as well as outside the school.
Thank you.
Senator Khan has a question.
Thank you, Madam Chair. Mr. Skibby, thanks for taking this question. I was surprised at the testimony from the school resource officers, and it seems that they tried to explain that there's the trade-off between doing assessments upon a delinquency petition and and the time delay in doing the assessment that there was a trade-off in that. Can you address that this can be accomplished in a timely way and the benefits of doing this prior to determining services to be delivered?
Sure, thank you for the question. I think, I'm just bringing up the amendment, but my understanding is that these assessments will be conducted within
30 days.
30 days. So I think you heard from Director Ripson that, typically there's at least a few weeks and oftentimes longer between the actual incident and the police becoming involved and the case being brought into court. And that was certainly my experience when I was a practitioner. It was my experience, when I've spoken to practitioners in recent years. So unless things have really dramatically changed, this sort of a timeline would fit quite well into the current case processing schedules that you typically find around the state. So it would mean that rather than people defaulting to filing a petition, sometimes for the purpose of trying to understand what service needs might be, and then hoping that the court will address them appropriately, they'll be able to get that information at the front end and possibly avoid court involvement.
Thank you. Thank you for addressing the question. And Madam Chair, I don't know if there's anybody else who might want to address that question, but it seemed like it was the point of the previous testimony. Anyway, maybe there's somebody else who'll testify and can ask it again. Thank you.
Thank you very much. We do have one other person, Senator, who would like to testify. Are there any further questions for Mr. Skibby? Okay, seeing none. Thank you very much, Mr. Skibby. Next, we're going to go to the child advocate.
Good afternoon, Madam Chair and members of the—
Good afternoon.
Thank you so much for having me today and hearing my testimony. We are testifying in support of Senate Bill 94. I have submitted written testimony for you to read at your leisure. And so I'll just go through a couple of issues that I want to just make sure that we've addressed properly. And in particular, I want to reiterate the purpose of this proposed change to the system. It certainly seems logical that placing children under court-ordered supervision would ensure safety for the community. And in fact, that's not the case at all. When children's needs are met, the incidence of reoffending is lowered, thereby lessening risk to the community. We know now from extensive research that the typical punitive manner of probation or incarceration is not an effective strategy for reversing delinquent behavior. To the contrary, as Attorney Wongarin noted, any involvement at all in the juvenile justice system is the primary indicator of reoffending, committing more crimes, poor school performance, and other negative outcomes. Probation actually has insignificant effects on reoffending, and especially poor results with children who start out at a lower risk of rearrest. A recent study in Orange County, California showed that diverting youth from court versus formally processing them in court resulted in being less likely to be suspended from school or rearrested and far less offending behaviors. And you've heard my testimony on other bills. I always bring it back to the developing brain of a child. The research findings on the effectiveness of probation and incarceration aligned with what we know about the brain, in particular critical thinking and insight as it develops. Children can learn and adjust their antisocial behavior in the right conditions. And the best analogy I can offer you is in terms of the right conditions are a flower garden, when you have the right soil, sun, and water. So the right sun, soil, and water for brain growth is trusting relationships with adults, a stable environment, and positive reinforcement. You teach a child to smile by smiling at her. So identifying needs and responding to them will nurture those relationships, stabilize environments, and put children on the path to success. You've also heard today that a significant number of children enter the juvenile justice system because of unmet mental health needs. This new process is going to direct children to where they can access the necessary care without them getting caught up in the juvenile justice system. So our office has seen a couple of examples of children who could have benefited from this proposed needs assessment. Recently, we received a call from a child's attorney who's worried that her client, whom she believes to be mentally ill, is not getting the care and treatment that the client needs. So under Senate Bill 94, a pre-petition assessment would have been conducted by the Department of Health and Human Services, and the child's needs perhaps negated even the need for an attorney because they would have been directed to the services they need. But if the child were adjudicated, the attorney and the parents would already have the assessment report in hand and would be able to advocate for the recommended care and make sure the child's needs are met. And then the people who really know what works best in juvenile justice are the children themselves. And we asked them, what do they need to succeed? They said they need things to do in the afternoon and safe places to play. Many also noted that their parents need mental health or substance use treatment. One described the ineffectiveness of doing the work of therapy when a parent inevitably would not participate. A police officer recently told us that children are better off in the juvenile justice system because their parents are too dysfunctional to help them. So this isn't an effective way to do juvenile justice or child welfare for that matter. It's far more likely a child will get back on track if the child's needs are identified and met appropriately. So this bill ends the need for children to be adjudicated just to receive needed services and treatment. And my follow-up on Officer Lewellen's concerns about limiting police actions, as Mr. Skibby said, it doesn't limit, but it actually gives more information. What's even more important is that if the child is adjudicated, the assessment's going to drive treatment for children in an individualized way to increase the likelihood the child benefits from being under supervision or incarcerated, and therefore leave the system much less risk for the community. So I'll stop there and appreciate you taking my testimony. If you have questions, I welcome them.
Thank you very much for your testimony, Ms. O'Neill. Are there any questions from the committee? Okay, seeing none. Thank you very much.
Thank you.
I see that that's the last person that we have, Margaret. Yep. So I am going to go ahead and close the public hearing on Senate Bill 94. Okay, since we're running behind, we're going to run right into Senate Bill 111. This is this again is another piece of legislation that I have sponsored. So I am going to turn the gavel over to Senator Gannon.
Wish I had a real gavel, but anyway.
Yeah.
Come on, Whitley. It was a good one. Anyway, Senator Carson, welcome back to our committee. Go ahead.
Thank you. Thank you very much, Mr. Chairman. For the record again, my name is Sharon Carson, and I have the pleasure to represent Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And I have for your consideration today, Senate Bill 111, relative to claims for medical monitoring. This bill establishes the elements of a claim for medical monitoring and damages that may be awarded. Mr. Chairman, medical monitoring is a result of exposure to toxic chemicals. Is an issue that came up before this legislature last year. The bill that passed last year and was vetoed by the governor was very broad and applied to any toxic substance, even substances that are not categorized as toxic, as long as they were proven by a preponderance of the evidence by an expert. It was too broadly written for a number of us, so my friend and colleague, Senator Harold French, and I drafted an amendment to scale the bill back to apply to exposure to PFAS. Ultimately, our amendment was not adopted, and the broad bill ended up being vetoed by the governor. Senate Bill 111 is modeled after the amendment that Senator French and I brought forward last year, and it limits the scope to exposure of PFAS. I also have an amendment to present to the committee this afternoon that further addresses two issues that were raised in the governor's veto message. The first is the need to show actual physical injury, and the second is to take into consideration past medical history. Quoting from the governor's veto message of House Bill 1375, he noted, "Many substances that qualify as hazardous are not associated with very limited health risks." By not requiring proof of injury or symptoms and excluding plaintiffs' past or present health status from being considered, House Bill 1375 could open the floodgates to new, less severe claims that would divert resources from those who are truly in need. He went on to say that House Bill 1375 could lead to the unfortunate consequence that those most in need are unable to receive what they otherwise would be entitled to. Amendment 21079S addresses both of these issues. It requires the plaintiff to show that their exposure to PFAS caused some kind of molecular injury. It also allows the claimant's past or present health status to be taken into consideration. New Hampshire would be just one of a handful of states to establish a claim for medical monitoring. If we are to do so, I believe a tailored and responsible approach like the one we have in this amendment is the way to go. I will be happy to try to answer some questions, but please note there are some very qualified legal experts who have signed up to speak that can address the current law and how this bill would change it. Thank you very much, Mr. Chairman.
Thank you. Quick question, Senator Carson. And I look forward to hearing the experts' testimony because I think that'll be informative. But the causality, so you have to, in your amendment, causality is so hard to prove. I'm going to listen to their testimony. I'll come back.
Okay.
Yeah, why don't we do it that way? Thank you.
Okay, thank you.
Anyone else?
And I misspoke. I believe the amendment number 0766S.
Okay. Thank you, Senator Carson. Does anyone have a question for Senator Carson? Very good. Thank you.
Thank you. Thank you very much, Mr. Chairman. I'll take over. Next, we are going to have Greg Smith.
Hear me now? You can hear me?
Yes.
Yes, we can.
Thank you. I think I appeared in opposition.
Up a little bit, Attorney Smith.
Yes. Can you hear me now? All right.
Yes, we can.
Yes, I've got a microphone on here. I'm not quite sure why. That's hard. So I appear in opposition to Senate Bill 111, as I have on similar proposals several times in the past couple of years. I'm sorry. I'm also having someone call me. And I represent waste management. I'm at the McLean Law Firm, have appeared over the years on behalf of many clients, individuals and businesses. And my practice focuses on environmental law and all of the ways in which we deal with it. So as I said, I appeared again in opposition to the bill as it originally was introduced, which was very broad and would have allowed claims, I think, in the most extreme fashion in the country. To the extent I have any research available to me, I think there are a minority of states allow medical monitoring at all, and only I think about 5 allow it as a separate cause of action, rather than a remedy at the end of a traditional lawsuit. So any effort to retailer and focus this bill that would bring it more in line with what the common law of injury cases, as we all understand it, would produce is certainly an improvement in my view in the bill. It is my understanding that the direction of the amendment is to respond to and take into account the objections that the governor had in vetoing the proposal last year. So I think it's an effort to make the applicable standards much more typical of the way in which we normally handle tort law and injury law, as lawyers call it, and rely on sound science to make reliable decisions. I think moving this proposal in that direction is a far better implementation, as I see it, of public policy in this area. I don't know that I have anything else to add at this point.
Thank you very much for your testimony this afternoon, Mr. Smith. Are there any questions from the committee? Senator Gannon?
Senator Smith, I'm sorry. I apologize for I read the bill quickly. I haven't put in enough time to it. Can you just run down what they would have to show a causal relationship to whatever exposed them to their damages, their illness, before they would get any? Walk me through how this works, how it would work, in your opinion. I don't understand it yet. I'm not on board, but I think I can get there if you give me a minute.
So I think the difficulty for those of us who have traditional notions of tort liability in mind is that when you enter this realm, this is something different. So ordinarily, we would think in terms of a plaintiff demonstrating that a defendant's liable for causing some injury. And if they can establish that in a court of law, then you move to what remedies they'd be entitled to. And it's my understanding that in a minority of states, medical monitoring is one of the remedies that can be ordered based upon such a trial. Now here, this proposal, which has come up several times in the past 2 or 3 years, is different in the respect that it creates a new cause of action. And the new cause of action, shall we say, short circuits that normal trial process. So instead of having to litigate the case and demonstrate liability and then get to the remedy, this inverts that process and says, within whatever standards you decide to shape here, that the plaintiff has to have evidence of that the defendant negligently caused exposure, and the legislature has previously inserted the notion of significant exposure, because there's a lot of ways in which we could have casual exposure to things and it's not going to matter. There has to be a sound science determining that there's a significant increased risk of illness or disease or a latent disease. And there have to be medical monitoring measures that established science teaches us can be used to detect whether someone having had a significant exposure may have a greater risk than the general public to developing a disease they have not yet developed. The way in which this bill has been proposed each time has, shall I say, watered down some of those requirements. I think the effort today, as I understand it, is to move to a more traditional approach. So, for example, the older provisions, and the governor objected to this, would say that there would need to be no proof of any physical injury and no evidence of the plaintiff's other medical conditions could come into the court. And I spoke last year about those items. The idea of a physical injury is that we can assess the significance of the exposure by whether there's been any change in the plaintiff's physical condition. And I think that the current state of the law is that that could be even at the, at the molecular level. But we have to see some evidence that the person had some change in their physical condition as a predicate. So the governor objected to that not being required. And the other provision that he objected to was by excluding the evidence of medical condition of anyone who wants to get monitoring set up, and that could go on for some period of time, to see whether they're going to develop a disease. If you can't look at whether they've got other medical conditions that might matter, then I think for those of us who are lawyers, that provision meant that classes could be extraordinarily large. It would eliminate the typicality requirement for a class action. It would make us a place for forum shopping, because I doubt there's any other place in the country where somebody would be so relaxed and so easy to require monitoring for a very large group of people to see if any of them might develop any illness anytime in the following years. So that's what the governor was speaking to about objecting, and I think the bill had a number of, in its previous form, had a number of provisions that dilute.
Alicia, what are you doing? Alicia.
That was a cat, Mr.
Yes.
Smith. Pay no attention to that.
So the bill had a number of provisions that would dilute.
I'm
those
sorry
traditional
I'm sorry but I have to step away. So Senator Gannon, could you please take over
Sure.
everything?
Yes.
Thank you.
Thank you.
So
Go ahead,
I was trying to address your concern, which I think is an appropriate focus of concern. You know, we think as in the law about how we're going to hold one party liable to another one, and we don't just say, despite the fact that it's the butt of lawyer jokes, anybody can sue anybody for anything. That's not how it works. There has to be some proper zone of imposing liability on defendants based upon what they've done. So as I understand it, Senator Carson is trying to significantly narrow a bill that really wasn't at all ready for prime time, in my judgment, and get it back to something more like what the standards are that in that minority of states that have decided to provide this new cause of action. I think that's what she's trying to do here.
I'm on board the train. I wouldn't say I'm at the final stop, but you got me to understand what's going on. Thank you very much, sir. Does anyone else have any questions for Mr. Smith? Seeing none, thank you, Mr. Smith. Oh, no, I'm sorry. Senator Khan has a question for you. Unmute, Senator Khan.
Thank you, Senator. And Mr. Smith, the bill puts a 3-year limit on the coverage. In your experience, what would be the proper timeline? What's common when there is a preponderance of evidence showing that there's a case for medical monitoring?
Well, I think the backdrop to what you're considering is we generally have a 3-year statute of limitations for claims in New Hampshire for tort or personal injury cases on the one hand, or breach of contract on the other. That's something that the state adopted across the board, as I recall it, in the 1980s. But there's a very important feature to our statute of limitations, which says it's 3 years from when the injury occurred, or the activity that the law doesn't allow occurred, or 3 years from when the plaintiff knew of it or should have known of it. The should have known part of it can take years and years. So by an objective standard, the law asks, at some point you became aware of this problem, and or any reasonable person would have. You have 3 years from that point to still bring your claim. So it's not really 3 years, it could be 20 years. And my point is, that's the way we deal with claims across the board. That's very standard kind of idea.
Thanks for the clarification.
Thank you, Mr. Smith. Any other questions for Mr. Smith? Thank you, Greg. Have a great day. Thanks for
testifying. Thank you.
Okay, Jenny, who would be next?
I think Margaret's got the list.
Yes, I do.
Okay, I'm sorry.
That's okay. So I have Chris Appel.
Okay. Chris, are you there?
Just letting him in. There we go.
Hi, Mr. Appel. How you doing today?
Mr. Appel, your audio is very scrambled and we can't understand you.
I can. You said, "Good morning, committee members."
Really? It's afternoon, Senator French. Can you try again, Miss Chris? It's sort of coming up garbled on my end anyways, and I think most people's. Are you still there, Mr. Appel? What do you think, Margaret? Should she call back or?
Jenny, should I remove or disable this talking and then maybe we can try again after?
Yeah. Why don't we disable him and bring somebody else in, and Mr. Appel will come back to you.
All right. I have Marissa Chase.
Ms. Chase, good afternoon. Good to talk to you again. How you doing?
Good afternoon. Can you hear me okay? Okay,
Yeah,
thank
you're
you,
doing good. You're
especially
coming in
after the last audio.
You're Crystal.
Thank you very much for allowing me to speak today. I apologize. I just received the amendment to Senate Bill 111 briefly prior to the hearing. I was only able to run it by one attorney who, knock on wood, thinks it looks okay. So I originally signed in opposition. I would like to change that to neutral for the record. This is an important issue. I'm grateful to Senator Carson for bringing this forward to advance this discussion. We were in support of House Bill 1375 last year. This is a very murky area of tort law where normally in any tort, someone causes an injury to the other. The plaintiff has to prove 1, that they were injured, 2, that the other person owed them a duty of care, and 3, that because of the defendant's negligence, that caused the injury to the plaintiff. By a preponderance of the evidence, as Greg Smith testified, typically in New Hampshire, a 3-year statute of limitation is very common for all civil actions. What makes this different is someone who has been exposed to PFAS may not be able to necessarily present a physical injury. So requiring proof of a physical injury is kind of the antithesis to medical monitoring. You want to medically monitor someone. We have all heard the phrase penny wise and pound foolish. Prevention can cost less than care of the ultimate disease. That is the ultimate intent of medical monitoring. In many other states, they have adopted medical monitoring by way of common law, not by way of statutory changes. So this is a different approach than what we've seen in other states. I will say that there is a case pending in federal court in New Hampshire right now where the issue of medical records has come about. The judge did order that medical history be disclosed. So it's good to see the legislation addresses that. We do have a concern on, an appropriate medical test that shows the plaintiff suffers from a significantly increased risk of illness. We would just respectfully request to be involved in any conversation to talk more about what that means. As Attorney Smith said, a change on a molecular level. I don't know what medical test would be used to prove that or who would pay for that. So those are my only comments for now. And when I hear back from people far more versed in this than I will send them to you all.
Thank you, Ms. Chase. Does anyone have any questions? Well, you're in luck today, Oh, nope. Senator Khan got you. Go ahead, Senator.
I'm glad that my internet's good enough that you can see the hand go up. Ms. Chase, so 2 questions. One thing that I recall from concern last time this was debated was the concern about preponderance of evidence. And I think you addressed that in your statement that the medical monitoring, if you're in a high cluster location, may be necessary to observe a situation. So what qualifies for the start time for medical monitoring, and is preponderance of evidence, is there an alternative to that in the qualification for, as stated in this bill?
Thank you, Senator, for the question. I think you're asking 2 separate questions, if I'm interpreting correctly. So preponderance of the evidence means more likely than not. That is the typical standard in civil cases in New Hampshire. A much higher standard, for example, would be clear and convincing evidence, which is a standard of evidence when taking away someone's personal liberties, like involuntary commitment, that sort of thing. So preponderance of the evidence is pretty common. I don't I guess I don't really know how to address start time. The 3-year statute of limitations is 3 years from the date someone knew or should have known. And I think, Senators Whitley and Gannon can speak to this better than I, but I think that, by using flexible language like that, our courts have been able to apply these generally accepted standards to unique instances, and each case is judged on its merits. That's why there are these kind of, flexible definitions used commonly in tort law. I don't know if that answers your question or not.
Well, let me try it one other way. If I lived in a clustered cancer cluster community and knew that neighbors on multiple sides of me had demonstrated that they had complications from an exposure, would I be able to use the evidence of their medical records, or would I need to wait for my medical records prior to monitoring?
Are you asking if your neighbor's medical condition would be applicable to yours?
I'm asking about the cancer cluster kinds of things. I mean, that's the concern that I have heard communities express, that they know they live in a watershed or a spill area that has caused exposure, and while they have not demonstrated it, that others have, and that they're concerned and would want to request medical monitoring. Anyway, is that a qualification with preponderance of evidence?
I'm sorry, Senator Khan. I don't know the answer to your question, and I would rather say I don't know than misspeak. But I'm happy to have another conversation with you. I do have some materials from the St. Gobain case I'd be happy to send to the committee, where I believe they touch upon these sort of issues, legal remedies, and evidence presented. So I will pass that along to the committee, and it's a 54-page document. I'm sorry about that, but if there's an answer to your question in there, Senator Khan, then it'll be worth it.
How about some underlining? Thanks for your
Thanks,
Ms. Chase.
question.
Yeah, you read and give me just a synopsis, will you?
You got it, Senator French.
1 page, Harold, right? 1 page. Thank you, Ms. Chase. Anyone else? Senator Whitley? Nope, she's good. Okay, we are good. Thank you for testifying today. Good to talk to you, Marissa.
Thank you very much.
Okay, Margaret, where are we?
All right, so Mr. Appel actually called in on the phone. So
Okay.
we can allow him in this way.
Hello.
Hi, Mr. Appel. We can hear you this time much better.
Oh, that's fantastic. You'd think at a law firm they'd have better internet access. But, well, first of all, thank you for the privilege of allowing me to testify today, even if virtually. My name is Chris Appel. I'm an attorney at the law firm of Shook, Hardy & Bacon in Washington, D.C., and I'm testifying on behalf of the American Tort Reform Association in opposition to SB 111. And I apologize, I in my frantic rush to try to get on the phone, I missed some of the discussion, but feel free to jump in and interject if there's anything that has been covered or that I can address on the fly. But my goal here today is similar to testimony I provided to the House Judiciary Committee last month on another broader medical monitoring bill, is to provide more of a national perspective on medical monitoring and to discuss some specific concerns with this legislation. And some of these concerns might be addressed by the amendment that was mentioned at the beginning of this, but at least I can give more background on why such amendments would be prudent. I thought I would begin by just re-emphasizing what medical monitoring entails. It allows a claimant to recover damages where he or she has no present injury and will likely never develop an injury. And that basic idea is a fairly radical concept in tort law. the existence of an actual injury has traditionally been the linchpin for tort liability. And one of the basic problems with allowing the unimpaired to recover damages is that it depletes the pool of resources available for those who have actually suffered a serious injury. And this isn't just hypothetical asset depletion either. The history of asbestos litigation in America provides a helpful example. There, a few courts around the country allowed tens of thousands of unimpaired claimants to recover based on their mere exposure to asbestos. The result, in my view, is fairly predictable. Unimpaired claimants flocked to these jurisdictions, draining the available assets for individuals who developed mesothelioma and other cancers. Manufacturers were forced into bankruptcy, leading to the creation of asbestos trusts, many of which now only pay pennies on the dollar to the seriously impaired. And the asbestos litigation parallel also seems particularly relevant to a bill focused solely on exposure to PFAS, given that many legal experts have said PFAS is poised to become, quote, the next asbestos. In any event, this type of concern led the U.S. Supreme Court to reject medical monitoring, albeit under a federal statute, and most state high courts that have considered medical monitoring in the past 20 years have expressly rejected it, including, for example, the Illinois Supreme Court just last year. SB 111 would not only adopt a new cause of action for medical monitoring, which I can explain, I think, which has already been explained, is a minority approach among the minority of states that do allow medical monitoring, but the legislation would do so in a very broad manner based on other considerations. And now you might be thinking to yourself, but this bill only applies to PFAS. Isn't that pretty narrow? Well, compared to other medical monitoring proposals, such as the House bill I referenced, SB 111's application to PFAS only does appear narrower in scope. But that doesn't mean that the bill still doesn't contain significant flaws and isn't susceptible to litigation abuse. And here I thought it would be helpful to just go through some of the bill's provisions. First, the bill provides that any PFAS and related compound can give rise to a lawsuit. Now, as members of this committee are probably aware, there are thousands of PFAS in existence that are in hundreds of products, and the number of PFAS is actually increasing. In fact, there are so many substances that the EPA hasn't even evaluated all of them yet to regulate them and tell us what unsafe levels are. And what the EPA has said, though, is that most people in America have been exposed to PFAS. So what this means is that SB 111 would necessarily apply to exposure to potentially thousands of substances, many of which have not been recognized under state or federal law as hazardous, and for which most people have been exposed. In other words, most people could be potential plaintiffs in a lawsuit to recover medical monitoring costs. And under the bill, a plaintiff only needs to show through an appropriate medical test, a phrase I'll return to in a moment, that a significant exposure to PFAS created an increased risk of illness. There's no threshold for how significant or insignificant that increased risk must be. The bill also expressly says that a person does not need to prove that illness is certain or likely to develop as a result of the exposure. It can be primarily speculative. And the bill's reference to an appropriate medical test evidencing the need or the increased risk could also be interpreted to mean almost anything. For example, does simply talking to a doctor and telling him or her about exposure to PFAS as part of a medical examination constitute an appropriate medical test? Who knows? I don't know. The only real safeguard appears to be whether an alleged increased risk makes diagnostic testing reasonably necessary. And there doesn't even appear to be a requirement that a doctor must make that determination. The bill twice references increased risk based on, quote, the latest medical science. But a lot of medical science isn't developed by doctors. The bill says that diagnostic testing must exist and be reasonably necessary, but the difference between reasonably necessary from, say, the perspective of a grad student doing medical research versus medically necessary from the perspective of a doctor could be considerable. And the bill includes another provision stating that the costs and necessity of periodic medical or monitoring examinations must be proven by expert testimony, but again, there's no clear requirement that a doctor is making that assessment. Even if the bill did explicitly require a doctor or other medical professional to make the determination, all an attorney would need to do is find one willing to opine that something is worth keeping an eye on which really isn't a tall order. And this is editorializing, admittedly, but in my experience, many doctors believe the practice of defensive medicine is a very real thing. So some doctors may be inclined to okay monitoring based on more questionable PFAS exposures, particularly given the uncertainties at the federal regulatory level, which could create potential for abuse, especially where a doctor is maybe pressed by an attorney to okay testing. The bill also says that a claimant's present or past health status shall not be at issue in a claim for medical monitoring. And I recall at the beginning that might be a provision that's going to be strict, but if it stayed in, like if a person has a pre-existing condition, for example, a genetic predisposition to something like breast cancer, that information would appear to be unavailable for use by a defendant in a medical monitoring case. In other words, the defendant could not argue that a plaintiff's increased risk of disease was due to factors such as genetics and not an alleged PFAS exposure. And I would just submit that stripping away such basic defenses would allow liability to be imposed in a fundamentally unfair manner. The bill also expressly authorizes awards of attorney fees and would give courts the option of awarding damages for monitoring as a lump sum instead of requiring that funds be placed in a court-supervised program administered by medical professionals. And this combination can be a recipe for mischief because it provides an incentive for attorneys to actively seek out litigation and recover medical monitoring damages on behalf of a group or a class without any requirement that any of the unimpaired claimants actually use the funds for monitoring purposes. There doesn't appear to be anything in SB 111 prohibiting a successful claimant who receives a lump sum damage award from, say, going out and buying a TV. And finally, I know I've been covering a lot of ground, and we can, break it down further if need be, but the bill's 3-year statute of limitations appears to adopt a purely subjective standard as opposed to an objective standard, which is antithetical to the purpose of a statute of limitations to establish a definite period after which claims can no longer be brought. And this was discussed a little bit before that part of it I was able to hear. But the limitations period appears to be triggered only by a claimant's actual discovery of his or her PFAS exposure, not when the claimant reasonably should have discovered the exposure. The bill provision stating that the date when the PFAS was released is immaterial further suggests a purely subjective limitations period in which claims may be brought based on alleged exposures occurring many years or decades in the past. And so the end result is a bill that would subject many businesses and other entities to potentially massive new liability exposure overnight at a time when many are struggling to just keep the lights on during the pandemic. And for all of those reasons, I respectfully urge the committee to reject this bill, and I'd be pleased to answer any questions.
Thank you very much. That was a lot. Does anyone in the panel?
Yeah, I apologize.
Go ahead, Senator Whitley.
Thank you, Mr. Chair, and thank you for taking my question. Based on your testimony, sir, I'm just curious whether you think any polluter should have to pay for the damage they've caused.
Well, I mean, of course, polluters should have to pay for damage they cause. I mean, tort law exists for that very purpose. If you injure someone, you should pay the damages, and it's a question of balancing of interests when you're dealing with a subject like medical monitoring. If you allow medical monitoring for unimpaired or asymptomatic plaintiffs, you're depleting the pool of resources available for those who develop mesothelioma, for cancers and who actually get sick and are dying. And so just from a policy perspective, I would argue that it makes better public policy sense to stick with the traditional physical injury requirement that's been a fundamental principle of tort law for centuries. And when someone develops a physical injury, it's not like they can't recover all the costs of medical monitoring monitoring they've incurred. I would just argue that it makes more sense to look out for the people who are going to get sick to make sure they have assets to recover from.
Follow up? No, okay. Thank you very much. Anyone else in the committee with any questions? I'm watching that hand, Senator Khan. It was close. No, are you all set, Harold? Okay. Okay, we are all set. I appreciate your testimony. That was very good. Thank you. Who do we have next, Margaret?
I don't see anybody else on our list. So if you are looking to testify, if you could virtually raise your hand. Nope, I do not see anybody else.
Okay, I guess that'll end our testimony and SB 111. What were we doing next, Margaret? Jenny?
So up next is Senate Bill 154. So it's up to you how you want to proceed, Senator.
Okay, give me 2 seconds. Oh, is Senator Bradley here? Is he presenting the bill?
I believe he is, yes.
Okay, so
We're still open on 111.
what's that?
Oh, have we officially closed 111?
Yeah, I'm sorry, I was about to. Thank you, though, Senator Willie. Great, okay, SB 111 is closed. 154, moving on. And Senator Bradley, I believe, is here to introduce it. Go ahead, Senator Bradley, if you're there.
Good afternoon, Mr. Chairman, members of the committee. Pleased to be here as the sponsor of Senate Bill 154 and want to thank all of the sponsors of the bill. Very simple bill. There's been a lot of discussion about executive orders regarding Second Amendment rights that all Americans have to keep and bear arms. If there are executive orders from President Biden restricting one's ability to keep and bear arms, this bill makes it clear that there could be no power of the state of New Hampshire to enforce any such executive order issued after January 20, 2021. Very simple bill, and I hope that you can join me in supporting it. Thank you, Mr. Chairman.
Thank you, Senator Bradley. Senator Whitley, go ahead.
Thank you, Mr. Chair, and thank you, Senator, for taking my question. Are you aware of any executive order currently coming from President Biden?
There have been none that I am aware of yet, but there certainly has been a lot of discussion about such executive orders. There's been a discussion that President Biden will declare a public health emergency that enables him to further make executive orders. So this would protect New Hampshire citizens who have the right to defend their lives, their loved ones, and their liberties from having those rights restricted.
Follow up?
Yep, go ahead, Senator Whitley.
So I haven't heard the discussions consistent with the executive order that you've referenced in this bill. So I'm wondering where you've heard those discussions.
They're all over the news. And I would say no further than when President Biden was a candidate, he was on TV, telling former Congressman Beto O'Rourke that he was going to be the point person. Certainly, the vice president has indicated that had she been president, she would have taken executive action. So I think that it's very likely that this happens. But you're right, to date, it has not happened. But there have been numerous executive orders. This protects, as I said, New Hampshire before, should these executive orders happen.
Thank you.
Thank you, Senator Bradley. Anyone else? Senator Khan, go ahead.
Thank you, Senator. Senator Bradley, thank you for taking the question. But we've got a couple of amendments, and I'm just curious if you have seen one from Senator Gaida and one from Senator Carson, and if there's one of these that you do prefer, or do you prefer to stay with the bill as presented?
So I have spoken with Senator Gaida. I have not seen his amendment. My understanding is Senator Carson's amendment includes in the language about firearms, also protection on, I believe, on knives. And that I have seen and have no problem with that amendment of Senator Carson's.
Anything else follow up?
Thank you.
No. Anyone else? Okay, Senator Bradley, thank you very much for your testimony.
All right, thank you very much.
Okay, Margaret, who do we have next?
All right, so I have a list of names. I'm not sure, Jenny, if there's a certain order that I should be going in. Just start at the top. All right. So first I have Dina Romero.
Okay. Dina, can you hear us?
Yes, can you hear me?
We can. Thank you. Go ahead, ma'am.
Thank you. It always takes a second to unmute. Thank you for allowing me to testify on Senate Bill 154.
If you can just tell me if you represent anyone and where you're from.
Yes, sorry. I'm Dina Romero. I am representing myself as a member of the public, and I live in Hanover, New Hampshire. I will add to that that I am a grandmother. I'm a retired social worker and a grandmother of 2 children who live in Bethel, Connecticut, which is right next door to Newtown and Sandy Hook. So I have submitted the testimony in writing, which I hope has arrived, and I'll just read from it. So I strongly oppose Senate Bill 154 for the following reasons. Gun violence in the United States is a public health crisis. Denying that we have a public health crisis because of gun violence is denying facts. SB 154 is one of several bills this year in the New Hampshire legislature that seeks to expand the rights of gun owners to use deadly force. If we continue to give more and more territory to firearm owners, New Hampshire is going to end up being a Wild West state of vigilante justice. In a society, rights come with responsibilities. It is time for gun owners to accept reasonable limits to gun ownership to protect the public. An example of a reasonable limit is requiring proper storage of firearms in the home to limit unintentional shootings by children playing with an improperly stored firearm. And finally, wouldn't a legislature serving the good of all New Hampshire citizens, not only gun owners, wouldn't the legislature want to participate in finding solutions to gun violence? Any legislation expanding gun ownership rights in our communities is, in my opinion, not a solution. Thank you for your time.
Thank you, ma'am. Does anyone have any questions for Mr. Romero? Thank you, Mr. Romero, for your testimony.
Thank you.
And Senator Gannon, I did see Senator Gaida had his hand up, so I'm gonna bring him in first.
Senator Gaida, good afternoon. Welcome to our Judiciary Committee.
Thank you, Senator Gannon. It's an honor to be here. I would defer to your judgment as to whether you'd like to hear the remainder of the bill, hear the speakers on the bill, and then bring in my amendment, or to bring in my amendments now.
Which do you want to do, Jenny, now?
I think Senator Gaida, if you're comfortable bringing forward your amendments now for the committee's consideration, that's the best way to move forward.
Sounds great. Very good. Go
Thank you
ahead.
very much, Mr. Chairman and Jenny. So at this time, Senator Bob Gaida, District 2, introducing Amendment 0734S. This amends the title of the bill and also amends by replacing Section 1. And I'd like permission to speak to that.
Speak to it, sir.
Thank you, Mr. Chairman. So Senator Bradley is a well-known champion of gun rights, but in light of the onslaught of discussions and news media reports about pending truncation of our Second Amendment rights guaranteed not only federally, but also in our state constitution, I produced this amendment which expands beyond executive orders It expands to federal statutes as well and regulations as well. And I do so because in the opinion of 2017 Attorney General of New Hampshire, our law enforcement officers are not required to enforce federal law, but that's not codified anywhere. It is practiced, but not codified. And so this amendment, and it's very simple, using the authority of the General Court under Part 2, Article 5 of the New Hampshire Constitution, no person acting under color of state law shall take any action, expend any funds, or exercise any power of the state of New Hampshire to enforce any executive order of the President of the United States or any federal rule, regulation, statute, or mandate to ban, restrict, or regulate firearms, ammunition, magazines, or other ammunition feeding devices, firearm components, firearm supplies, or knives. Very comprehensive, very simple. And it is a statement as to the sovereignty of our state when it comes to our constitutional rights and the ongoing war that goes back and forth depending upon administrations, whether to sustain our freedom or whether to try to truncate it further. Under color of law means acting under the authority of any federal, state, or local law enforcement capacity as interpreted in this bill. And so we would restrict and carry out into statute that which is already in practice but not codified. I'll take any questions.
Haven't seen any yet. I'm giving them a second to go and gone. Thank you, Senator Gaida, for your testimony.
So, sorry, Senator Gaida, I believe you have a second amendment as well.
Yes, ma'am. And if I may, Mr. Chairman.
Go ahead.
That second amendment would be applicable to whichever version of the bill survives. And so I'm not sure whether to bring it in now or to wait until later. You're
Go now. Gotcha
okay.
now. We'll go now.
All right. So let me pull that up.
Can't help but notice this is a Second Amendment.
That's right.
Good one, Jay.
Fitting.
Bear with me just a second here.
Sure.
All right, I'm struggling technologically to pull up that second amendment, but it's a very simple amendment.
Yep.
I've spoken with the chiefs, I've spoken with the police officers, and I've spoken with the Troopers Association. The second amendment would codify that any order contrary in spirit or letter to the provisions of this statute is in fact an unlawful order. And the reason for this amendment is that there are some of our officers are engaged in task forces involved with federal law enforcement, and also in the very unlikely but possible occasion that a superior officer may feel compelled to tell an officer to participate in federal action. Making it an unlawful order gives them the protection against having to carry out an order that's in violation of our state statutes, and protects them from internal discipline if that should occur.
Okay. Pretty clear. Any questions for Senator Gaida? Okay, seeing none. Thank you, Senator Gaida.
Thank you, Mr. Chairman.
Okay, Margaret.
All right, next I have Robin, and I'm gonna mispronounce the last name, so I'm just gonna allow Robin in.
I'm not going to guess either, Robin.
Hi, Skudlaric.
Okay.
Skudlaric, yes, hi. Hi, thank you, Mr. Chairman and Senate Judiciary Committee members. My name is Robin Skudlaric. I'm a resident of Londonderry, a business owner, a mom, and I'm a volunteer with Moms Demand Action. I'm here today in opposition to SB 154. This bill would prevent state and local law enforcement from enforcing federal executive orders related to firearms and gun violence prevention, sowing confusion, and tying the hands of law enforcement to keep their communities safe. SB 154 would prohibit state authorities including courts and law enforcement agencies, from enforcing federal executive orders that restrict or regulate the right to bear arms. This broad, vague pronouncement could be applied to a wide range of executive orders designed to prevent gun violence and keep communities across New Hampshire and the nation safe. Executive orders can help prevent gun violence in a number of crucial ways, including addressing gaps in federal law that have allowed the proliferation of unserialized ghost guns, which can be purchased without a background check and are untraceable by law enforcement. Addressing the Charleston loophole, which allows illegal gun sales to go forward before a background check is complete. Keeping guns out of the hands of those who shouldn't have them by alerting local law enforcement when a prohibited person tries to buy a gun but fails the background check. Expanding dealer regulations to crack down on a booming online market for firearms, and strengthening the background check system by encouraging states to report all prohibiting records for inclusion in federal databases. All of these efforts would be undermined in New Hampshire if SB 154 becomes law. Nullification bills like SB 154 cause confusion, make the job of law enforcement officers more difficult, and endanger granite staters. So I urge you to oppose SB 154. And I've also emailed you guys my testimony. I just tried to be brief about it.
Thank you. Just a simple question from me. I'm not aware of the Charlestown loophole. Is that a time restriction thing?
Yeah. So Dylan Roof, who murdered all of the people in the church in Charleston, was able to obtain a firearm because the 3-day background check hadn't been completed.
Okay, I understand. Thank you very much for your testimony. Any questions?
Thanks.
Seeing no questions, I thank you for calling in with your testimony.
Thank you all.
Have a great day. Thank you. Okay, Margaret.
All right, next I have Aaron Pankasik.
Aaron, welcome to our Judiciary Committee. How are you doing today?
Thank you so much. Thank you, Mr. Chairman and committee, for hearing my testimony. I'm Aaron Pankasik, and thank you for actually pronouncing it correctly. That's the first time in my entire life that's happened. I live in Hollis, New Hampshire, and I'm here testifying in support of SB 154. I'm just going to make a handful of points here that I think are relevant to this. First of all is relative to executive orders that may deal with firearms control. Vice President Harris in April stated that if nothing happens in the first 100 days of President Biden's office, that an executive order on firearms control would be drafted. All right, so there, and that's documented. She made that statement in April. 154, earlier it was stated that 154 expands gun rights. It doesn't expand gun rights. It maintains the status quo with gun rights. It doesn't expand them. Firearms are one of the most highly regulated products in the country. People talk about these ghost guns. Well, that's a myth, right? Because I work in a firearm shop, right? And lower receivers that you would require to build one of those firearms are serialized. And to purchase that gun part, you have to go through a NICS background check, right? And in New Hampshire, it's considered an other, right? So the pistols and others go through the gun line, through the state police. Long guns go through the feds, the FBI, right? And in my experience, the FBI long gun checks come back within 15 minutes these days. Seldom do you ever see 3 days where you have to do that. Even the gun line checks, which are onerous, come back in 15 to 30 minutes, right? So there's a lot of misinformation out there on some of these points. I would also point out that with regard to Second Amendment sanctuary states, Tennessee, Ohio, Oklahoma, Arizona, and Arkansas have passed similar legislation already. They're pending right now with the legislation. The ones that have passed it are Hawaii, Idaho, Wyoming, and Kansas, right? So they saw fit to do that and saw that it was constitutional, both with regard to their state constitutions and with regard to the United States Second Amendment Constitution. There are more than 60 bills that are anti-firearm bills on the table at federal level right now. Right? And it's only logical to assume that some of those would end up as executive orders. Also, if you go look at the statistics, there's a study that was done in 2019 by the Center for American Progress, right? And they're actually not pro-gun, right? But it covers statistics from 2007 through 2017, and it puts New Hampshire at number 41 out of 50 in the number of gun deaths within the state. You know, so we're way down there. We don't have a gun problem in New Hampshire. We don't need any more legislation, more laws, and there are already dozens of them on the books. More laws are not going to change anything. The problem isn't the guns. The problem is the criminals that use them. And let's see, I think I'll leave it at that.
Okay.
Thank you for my opportunity to testify.
Thank you. Any questions from any of the panel? Aaron, thank you very much for your testimony today. You have a great day.
Yes, sir.
Okay, Margaret. Easy to pronounce name?
Yes. We have Tracy Han Burkett.
Hi, Miss Ann Burkett. How you doing today?
Good. Can you hear me?
Yes, we can. Thank you. Go
Great.
ahead. If you could limit your testimony to sort of, rather than a broad gun thing, just to the executive order, why you are for it or against it.
Yes, I will do that.
Awesome. Thank you.
Yep. My name is Tracy Han Burkett, and I'm here on behalf of myself and also as the leader of the Kent Street Coalition's working group on gun violence prevention. And thank you for the opportunity to testify today. And I am from Bow.
Thank you.
I'm testifying against SB 154 today. Executive orders are the law of the land, and they can go before courts just as acts passed by Congress and signed by the president can go before the courts. For some reason, though, this is a bill carving out the orders of a specific president in a specific issue area for special enmity and attention. And this is at a time when the movement at the federal level in this area seems to actually be taking place in Congress. And I know that now there's an amendment because that was just discussed to rope in also legislation making this even broader. I don't think that that is curative, however. This bill is at best unnecessary, and it doesn't seem to have any real purpose other than to give the most ardent supporters of the point of view that it represents something to rally around, because again, we do have the court system to challenge it. However, I would like to focus for a moment on the breadth of the bill and what it means in the context of the sweeping nature of the whole collection of gun elevating bills being considered by the state legislature this session. The collection of bills, and I definitely count this among them, seeks to place the gun in New Hampshire law and culture above everything else, above other preferences, above other rights, and above human safety and people's right to survive to the end of the day. Just for an example, consider the fact that we live in a state where approximately 90% supports universal background checks. And this is about this bill. I'm just using this as an illustrative example. So that 90% presumably does not include the gun lobby, but the vast majority of the population are not members of the gun lobby, although many of in the population may in fact own guns. But if the president of the United States were to issue an executive order subjecting gun sales to universal background checks, this bill would, in its own words, extend protection to firearms, ammunition, accessories, etc. And this is where I think the bill language really gives up the ghost here, because it protects the weapons, but not people, no matter what the people want. And so that's really the crux of what I'm here to say. There are real problems to solve in this state, even in this issue area right now, but throwing up a shield to fend off enforcement of the current president's non-existent executive orders because they might align with people's interests isn't among those problems. So I urge the committee to vote ITL on the bill and the amendments. Thank you.
Thank you, Ms. Hahn. Does anyone have any questions? Okay, no, looks like you're safe. Thank you for your testimony.
Thank you.
I have
Okay, Margaret.
I have Senator Gaida raising his hand again.
Sure. Go ahead, Senator Gaida.
Thank you, Mr. Chairman. In response to the very incorrect comments of the prior speaker, this bill does nothing to truncate federal law. It merely says that our law enforcement officers, as is currently the opinion of the Attorney General of the state, okay, are not required to assist federal law enforcement in their enforcement of federal law. It does nothing to change rights or executive orders. It merely states that our law enforcement officers are exempt from enforcing federal law, a practice that already exists but is being codified into law. Thank you, Mr. Chairman.
Thank you, Senator Gaida. Okay, Margaret, go ahead.
All right. Next, we have Alan Rice.
Mr. Rice, welcome.
Good afternoon, Mr. Chairman. Thank you so much. For the record, my name is Alan Rice, and I am a resident of Bedford, New Hampshire, and I am here as the New Hampshire State Director of Gun Owners of America. We support the concept of Senate Bill 154. We would like to see the amendment that Senator Gaida described, because the bill, as introduced by Senator Bradley, is very well intentioned, but it only encompasses executive orders. And as a previous speaker mentioned, executive orders that happen on or after January 20th, 2021. We would like to see the bill encompass statutory law as well as executive orders that involve any sort of a restriction on the right to bear arms. We should not be spending state resources, expending law enforcement resources, stretching municipal and state budgets that are already thin, enforcing federal law. If the federal government wants these laws, the federal government can enforce these laws using federal resources. State resources should in no way be used to enforce any federal laws. Clearly, it's a separation of powers issue, a 10th Amendment issue, and at its core, it's not only a Second Amendment issue. This would apply to really any federal law. We should not be using state resources to do the job of the feds. If they want it, they can enforce it. This downshifting is A, unconstitutional, and B, not healthy for the New Hampshire taxpayer. So I would urge the committee to strongly consider the amendment that Senator Gaida described and vote that amendment, and the bill ought to pass. And I would be happy to entertain any questions from the committee.
Thank you, Mr. Rice. I'm looking to see, but I don't see any questions at this time. Thank you, Mr. Rice, for your testimony.
Thank you.
Next, we have Elliot Axelman.
Mr. Axelman, welcome to Senate Judiciary.
Hi, thanks, guys. Thanks for having me. My name is Elliot Axelman. I live in Hooksett, New Hampshire. I strongly support Senate Bill 154, and I'm glad to hear just a few moments ago about Senator Gaida's amendments. I love both of those amendments, so I hope those are accepted into the bill and the bill is recommended to pass. I think this is not that controversial at all. I heard some speakers oppose this bill and some support it. This should not be controversial. It's about human rights. It's not about whether we love or hate Biden or love or hate guns. I happen to not support any president who wants to violate my natural human rights or the Constitution. But this is just about natural human rights, and especially about executive orders. If people in New Hampshire and Americans supported gun control as much as some of the previous speakers seem to claim, our legislature would have passed a lot of these gun control measures. If 90% of citizens really supported universal background checks, which we already essentially have, then it would have been passed by our legislature. But what we're talking about here, like Mr. Rice just mentioned, is our state law enforcement, state and local police and sheriffs helping federal government agents violate our natural human rights. Again, I've heard the constitutional argument, and I think it's a great argument. The Constitution clearly says it shall not be infringed. But I think the better argument, because the Constitution can be amended or reinterpreted by courts, the stronger argument is natural human rights. Every human being on Earth and every organism, every animal has a natural right to own property, even if that property is made of metal or polymer, or if it can fire a projectile. That's still property. I have a natural right to property, and anyone who wants to violate that by saying I can't own property and sending armed agents to kidnap or kill me or take my property is violating natural rights. So I think this is a great bill. I'm glad I hope the amendment passes so that it applies to federal laws, because I do suspect that federal laws as well as executive orders will pass. I was going to ask Bradley or Gaida if it was going to apply to state of emergency orders, because it's a little different than executive orders, but hopefully it applies to all federal laws. My one question for any of the sponsors, maybe Bradley or Senator Gaida, is would this not only prevent our law enforcement in a state or city from helping federal officials, but what if federal officials decide federal law bans all firearms and the feds do come in to take all of our firearms? Can we also maybe make an amendment to have our law enforcement actually stop or discourage federal agents from enforcing their laws? Because it's good that my local Hooksett police won't enforce the laws, but I don't want federal agents enforcing laws either. Can we actually stop them from enforcing laws that violate my natural human rights and my Second Amendment rights and my New Hampshire constitutional rights? Thank you very much.
Thank you, Mr. Axelman. Does anyone have any questions? Thank you for your testimony today. Okay, Margaret.
Next, we have Mike Thornton.
Mike, if you can keep your testimony, if it's already been said, you don't need to repeat it. So anything new you have to offer would be awesome.
All right, I'll try to do that. Thank you, Mr. Chair. And senators of the board, I appreciate it. I speak as myself. I'm a resident of Milford, New Hampshire. I'm both a Marine NCO and an Air Force officer in past experience.
Thank you for your service, sir.
You're welcome. Part of the reason I served was our Constitution, both federal and state. New Hampshire 2A, all persons have the right to bear arms in defense of themselves, their families, and property, and the state. That's pretty succinct. We have infringed that already by requiring background checks and everything else. That's fine. I agree with some of that. I agree with Senator Gaida and Mr. Rice that the amendment should be considered. I would urge you very much to keep New Hampshire's Constitution strong and to have it continue to have meaning. To do anything else throws us into complete disarray, and no citizen would have any confidence in the Constitution or any law whatsoever. Thank you.
Thank you, Mr. Thornton. Do we have any questions from the committee? Seeing none, thank you, sir. Have a good day.
That was all that I have on my list, but I do have a hand raised. Oh.
Sorry, Margaret, I think we had two other people that signed up late. So I think Connor Reagan had signed up to speak.
Okay, Connor, I don't see your name. If you could virtually raise your hand. We have one phone number already raised.
And then Jay Simkin as well had also signed up to speak a little later on, but I don't see Mr. Simkin on the list as well.
Okay, I do see a phone number that just popped up, so it could be one of them. So I will allow the phone number in first.
Can you hear us, sir?
Good afternoon.
Good afternoon, sir. If you could give me your where you're calling from and if you represent anyone.
My name is Jay Simpson. I am representing myself. I'm a longtime resident of Nashua, New Hampshire.
Thank you.
Some disclosures. I'm a federally licensed firearms dealer and have been so for something over 35 years. I'm also an international economic consultant. I will not take your time by repeating anything that's been said.
Thank you.
I will, by your leave, by your kind leave, Mr. Chairman, address some points made by others who have testified. In 2019, New Hampshire displaced Vermont as the second safest state in the Union, measured by the incidence of violent crime per 100,000 residents. New Hampshire, with a one-year exception, had been the third safest state in the Union since 2001. So those who testified at the very beginning, claiming that there's all sorts of violent crime, et cetera, there is some, but this is among the safest places to live in the United States. The fact that we have few laws regarding firearms simply testifies to the basic good nature of New Hampshire residents. My source for these statements is the FBI publication, Crime in the United States. It is available on the FBI website going back to 1995. Second, earlier witnesses testified that 90% of residents support background checks. Two things those in that 90% majority do not know. One, at end 2018, there were approximately 423 million firearms in the United States, excluding those owned by the military. I submit to you, Mr. Chairman, and members of the committee, that anything so numerous and mainly concealable can't be controlled. The other thing that the 90% majority doesn't know is that background checks are a consumer fraud. Here's why. There is basically no federal enforcement of the law. It's 18 U.S. Code, Section 922, small letter A, numeral 6, which makes it a federal felony for a person to lie to a firearm dealer in order to get a firearm. This is not my opinion. I would not waste your time with my opinion. It is the view of the Government Accountability Office, report number 18-440, which did a 13-state survey. And these were states which have the FBI NICS Center do all of their background checks. Of 112,000 denials recorded by the FBI NICS screeners, approximately 12,700 were referred by them to the Bureau of Alcohol, Tobacco, Firearms, and Explosives for investigation. Of the 12,000 referrals, there resulted exactly 12 federal prosecutions. So small a number of federal prosecutions basically tells us that background checks are a fraud because there are no consequences for those who lie to dealers to get weapons. I suspect all of this information is new to you. You can find the GAO report number 18-440 on their website and read it with your own eyes. So most of what you have been told, bluntly put, is balderdash. As to the state gun line, I do these background checks and I do them personally. I don't do a lot of them, a couple a week. I don't think I get any special treatment because I'm a small scale dealer. They generally take about 5 minutes, maybe 6 minutes from start to finish. Could the time be longer occasionally? I'm sure it could. The problem that led to the hours and days long delays was simply a rogue employee who decided that she was going to do background checks the way she wanted them done rather than the way they're done by FBI NICS. That employee apparently has been curbed, and now we have efficiently administered background checks. While I think background checks are a fraud, I swore to the Attorney General of the United States that I would do them diligently and correctly, and according to my sworn word, I do. As to this bill, it's fine, but what it lacks are the following things. One, there is no enforcement mechanism. If some state official seeks to help the feds to enforce some or another law or regulation, whether in the realm of firearms or other, and a New Hampshire resident is damaged thereby, what does that damaged resident do? In some cultures, they would go to the steps of the Capitol and commit suicide as a way of protest. You have to have enforcement measures for laws. So, given the huge costs of litigating with a state, I have had to do this in the Commonwealth of Massachusetts to recoup a wrongfully revoked concealed carry license. It isn't $50 or $100. I spent about $125,000 for 3.5 years of litigation. Therefore, in this bill, you have to add provisions that any resident aggrieved needs to go to either the district court or superior court, because that establishes jurisdiction. Second, a resident who brings a grievance needs to be reimbursed by the taxpayers, because that aggrieved resident is litigating on the behalf of every resident. And very few people can afford to write checks, note the plural, and they are big checks, $5,000 and $10,000 each, to an attorney to carry out this litigation. It's beyond the capacity of the average resident to do this pro se. How do I know this? Because by the kind leave of the New Hampshire Supreme Court, I appeared as a non-attorney representative for a friend who had a couple of firearm-related licenses revoked wrongly and wrongfully. An attorney handled one appeal, I handled the other. I wrote his brief, I paid for the brief to be printed, and I briefly argued his just cause before the court. This took hundreds and hundreds of hours. Most folks don't have the time, and even the bill for printing the brief would, for many people, be more than they could afford to spend, especially in the post-COVID era. So in short, you need to add to this bill penalties for wrongdoers, an enforcement mechanism for an aggrieved citizen, and reimbursement from taxpayer funds for that aggrieved citizen's costs to litigate this. Because as it is now, this bill is empty. It's not wrong, it's just empty. It just says you shouldn't do this and leaves it at that. Not adequate, gentlemen. So thank you for hearing my testimony. I am more than happy to take questions.
Are there any questions? No, I don't think so. Thank you very much for your testimony, sir. Have a great day.
You're welcome. Thank you for giving me the opportunity to testify, Mr. Chairman.
Thank you. Okay, Margaret.
All right, so we had Connor Reagan, but Connor, I don't see your name on our list. If you could virtually raise your hand. Okay, I still don't see Connor, but I do have one hand raised, which is Joe Hannon.
Okay. For Representative Hannon, is that you?
Good afternoon, Senators. Nice to see you, Mr. Chairman, and members of the committee.
Good to see you, sir.
My name is Joe Hannon. I'm the Vice President for Gun Owners of New Hampshire, and I'm testifying in support of SB 154. I'd just like to address a couple things that may not have been mentioned or were briefly mentioned. The notion that New Hampshire would turn into the Wild West without new infringements is a preposterous one. Like it was said, we're consistently one of the top 3 states in terms of safety. Also, the principle that laws are passed by the American people's elected representatives is paramount. This is how citizens have democratic consent, not by royal decrees. Supporting armed officers to engage in enforcement of more firearms laws increases the likelihood of increased violence. Now, way back, I learned in school there was considerable violence that resulted after gun control efforts in 74 and 75, specifically 1774 and 75. There's also a disproportionate effect on firearms laws on persons of color and the enforcement and conviction of those laws. Massachusetts had studies in the past few years that showed significant disparities in the enforcement of gun possession laws and the convictions for them. In light of these recent and past events, I think it would be very prudent to limit the opportunity for increased armed interactions with the government. And finally, we know that executive orders have been used in cases of extreme urgency. Gun control is something that has been argued ad nauseum by the US legislature and by our own august body of good senators and representatives here in New Hampshire. And out of all the potential executive orders or laws that are being proposed right now at the federal level, there is little that our own state government has not rejected time after time after time. And we are still one of the safest states in the union. And I ask you to support the bill, and I'd be happy to take any questions.
Thank you, Representative Hannan. Any questions? Joe, I hope you and your family are well. Have a good day.
Thank you, Senator.
Margaret?
All right, I don't have any other hand raised, but if anybody else is wishing to testify, if you could virtually raise your hand. I do not see any other hands up.
Really?
Really?
Awesome. Okay, so should we close 154? Sound like a good idea, Harold?
Yeah, do it.
SB 154 is officially closed. Okay, what's next?
Darren?
So I believe that concludes our business of hearings for the day, Senator.
Yay.
So I think you'd be looking for a motion to
Motion.
adjourn
I think
unless
I
Senator
have
Khan has something he'd like to raise.
He wants to adjourn.
And I'll second that.
Thank you, Senator French. Okay, we will do the roll. Senator Whitley,
Yes.
Senator Khan,
Yes.
Senator French,
Yes.
Senator Gannon says yes also. Very good.
Great job.
Thank you, everyone.
Great job
Have a
stepping in
great
there,
day.
Senator.
No, you sometimes have to step up.
No, you did. You did a fine job. I'm very proud of you.
Can you give me a call, Harold, in a few minutes? Something else?
Yeah, sure.